Hi everyone, in this video we will discuss some important case laws on Indian Constitution. This is part 6. The first case is Shankari Prasad versus Union of India 1951. In this case, the validity of the First Amendment was questioned, but the Supreme Court ruled that the power granted to Parliament under Article 368 to make amendments is extensive and includes the authority to revoke fundamental rights guaranteed by Part 3. Additionally, the court determined that in context of Article 13 Clause 2, the term law refers to rules or regulations enacted through regular legislative power and does not encompass constitutional amendments made through constituent power. Consequently, Article 13 Clause 2 does not impact amendments carried out under Article 368. The next case is Indira Nehru Gandhi versus Raj Narayan 1975. In this case, the validity of the 39th Constitution Amendment enacted in 1975 was challenged. The amendment, specifically Article 39A, aimed to exempt the election of the President, Vice President, Prime Minister, and Speaker of the Lok Sabha from the scrutiny by the constitutional courts. The Supreme Court, applying the theory of the basic structure of the Constitution, invalidated Clause 4 of Article 329A. The court concluded that this particular clause exceeded the amending power of Parliament since it undermined the fundamental framework of the Constitution. The next case is People's Union for Civil Liberties versus Union of India 2013. The Supreme Court addressed the issue of election reforms and affirmed that democracy and free elections are integral to the fundamental framework of the Constitution. The court determined that in a parliamentary democracy, the right not to vote is a component of the voter's right to freedom of expression as guaranteed by Article 191A, and it must be acknowledged and given equal consideration as the right to vote. To effectively implement this right, the court suggested the inclusion of a none of the above nota button on electronic voting machines (EVMs). This provision would provide voters with the opportunity to express their choice of not selecting any candidate, thereby compelling political parties to nominate qualified candidates. The next case is State of Madras versus Champakam Durai Rajan, 1951. The judgment resulted in the inclusion of subsection 4 through the First Constitutional Amendment Act of 1951. It was specifically prompted by a case where the Madras government had allocated reserved seats in state engineering and medical institutes based on various social categories such as caste, religion, and race. This allocation was challenged on the grounds that it violated Article 15 Clause 1 of the Constitution. The Supreme Court ruled that the provision invalidated the reservations based on race, religion, and caste as it categorized students based on these factors rather than their academic abilities. In response to this judgment, Clause 4 was introduced into Article 15, granting the state the authority to establish specific provisions for scheduled castes, scheduled tribes, and socially and educationally marginalized classes of citizens. The last case is Shreya Singhal versus Union of India 2015. Section 66A of the Information Technology Act 2000 made it a punishable offense for any person to send grossly offensive or menacing information using a computer resource or communication device. The Supreme Court struck down Section 66A of the Information Technology Act 2000 relating to restrictions on online speech as unconstitutional on grounds of violating the freedom of speech guaranteed under Article 191A of the Constitution of India. That's all for the day.